so 4 or 5 days.
Correct.
And certainly you had a washing machine and a dryer in your house, right?
Yes.
And, do we have exhibit 238, please? You can see the washing machine and the dryer in this picture, right?
Yes, I bought that 5 years before.
All right, and there's a suitcase there,
Correct.
some folded laundry.
Yes,
Is that a suitcase that you took to Florida?
that's correct.
And that's your laundry that you were doing? Doing?
Not necessarily.
Okay. You can take that down, please. All right, let's talk for a little while about what happened in the bedroom. When you grabbed Katie's neck with one hand, you were on the floor, right? That's what you're saying?
At the time that she struck me, I was kneeling on the floor and begging her to stop.
So I'm asking about the point in time when you put your hand on her neck. Were you still on the ground at that point in time?
I was coming up from my kneeing, grabbed her with one hand and used the other hand to protect or to check on my bleeding. Yes, I came up from my kneeling position, reacted to the threat of being struck.
So you were standing at that point in time?
I would say I was half standing toward the standing, probably. I don't really recall all that. I was pretty drunk.
All right, we'll talk about how drunk you were later, but I'm just trying to understand what you remember now about your position.
Well, I
You
could.
were half standing, half kneeling. Katie was on the bed. How was she positioned?
She was sitting on the bed edge, as far as I remember.
And what was happening with her hands?
She had, as far as I remember, a phone in one hand and a glass on the other hand.
And she continued to hold the phone and the glass?
At what time?
As you were strangling her, she continued to hold those items?
No, she struck me with the glass.
Well, she struck you with the glass first, and then you reacted to that, right?
Correct.
So that had already happened.
Sorry, what?
That had already happened. So the glass wasn't in her head and in her hand anymore, right?
That's what I was trying to say, but you said she had her glass in her hand. That wasn't the case at that time anymore.
So as you were strangling her, what was happening with her hands?
I don't know if I strangled her. I said I think I choked her.
Are you distinguishing between choking and strangling?
All I'm saying is that I really don't know what I exactly did because I was drunk and I was in a fight and flight reflex. So I really don't recall much extra that I really grabbed and tried to protect myself and defend myself.
Do you remember putting your hand, at least one hand, around her neck, right?
I said I think I grabbed her.
I'm asking what you're saying right now. Not what you said in the past. I'm asking right now.
And I blacked out from the struck. I was assaulted at this point in time and I reacted and I believe I grabbed her.
When you blacked out, are you saying you passed out?
No, blacking out means that I didn't really recall what I was doing. I reacted to a threat.
So
I snapped.
Okay, so the glass hit your head. You snapped. You had a flight or flight reaction.
Correct.
And you just reacted. I'm sorry, you said something else that I just forgotten. You blacked out.
I snapped.
You snapped. What else are you attributing to the glass hitting your head?
Fight and flight reaction. I was afraid.
And you said yesterday you were afraid of having to leave 29 Valley, right?
I was afraid of Katie too.
You didn't say that yesterday.
Because you compared that to physical.
One at a time. One at a time.
Sorry.
Yesterday you said you weren't afraid. You said
Because-
you were afraid of 29 Valley, of having to leave 29 Valley.
I was afraid of Katie too, but not in the physical sense that you try to explain. But it's not about being bigger or stronger sometimes. It's about who has the power. And she had all the power after I signed everything over I had to her. And I was very afraid of her with her intentions and her reactions. I was very afraid of Katie.
That was a shift in your relationship, right?
There was a massive shift in the relationship that she had massive leverage over me, yes. But yes.
All right. So at the point that she hit the glass in your head, she didn't have the glass in her hand anymore, right?
I don't think so.
So she had a phone
was-
in one hand.
At the time when she struck me, I don't remember or I don't recall what happened with the phone later or the glass, because it was all one blurred reaction to being hit.
Did you get on top of her?
As far as I remember, when I came out of my blackout, she passed out very quickly. There was no fighting, really, as far as I recall. But when I came back out of what the hell happened, we were both on the floor because we kind of slid off the bed and fell on the floor.
Were you on top of her?
I don't recall that.
Where were your hands when you were both on the floor?
I don't remember.
Were they around her neck?
Not sure.
Is it possible that you were slamming her head on the ground and that's how she got the injuries to the back of her head and her brain?
Well, we heard yesterday that wasn't trauma related.
I'm not asking about Dr. LaPosada's opinion. I'm asking about your testimony about what happened. And you have some gaps in your memory. So I'm trying to make sure that we understand exactly what you know happened and what you don't know happened.
Thanks.
So is it possible that you were on top of her with your hands around her neck, slamming her head on the ground?
I do not recall.
Is it possible that she put her hands on your hands in an effort to remove them from her neck?
There were no defensive wounds on Katie and no defensive wounds on me, so no.
I'm asking what you know about what happened.
Not that I recall. There was no struggle, no fight as far as I remember. I reacted to the hit. I felt threatened. I defended myself. And once I kind of recalled that I kind of came somewhat back, but I was still very intoxicated, we were both on the floor. And she was unresponsive.
Ms. Gilman, can we please have exhibit number 57? Could you zoom in, please? Dr. Tuerk, I'm going to put exhibit number 57 in front of you.
Please.
Yes.
Do you see this mark right here on your hand? On your finger?
On the middle finger, you mean?
Yep.
I see that mark, yes.
Isn't it possible that that's from Katie's fingernails?
No. Because there were no skin cells under her nails in the
I'm asking
forensics.
about your memory, sir, not about the forensic evidence.
It's not possible.
Could you turn to 59, please?
59. I have it.
Please. Do you see these injuries right above your thumb?
Yes,
Isn't that possible? That's from Katie's fingernails?
they were from the bushes I walked through, not from Katie.
And those were documented by the police, right?
I believe so.
took efforts to document that, right?
Correct.
Can I go lights back on? All right, let's talk about what you did after you killed Katie. You carried her out of the house, right?
More direct after? No.
Didn't say direct. Just said after you killed Katie, you carried her out of the house.
After a while, I carried her out of the house, correct.
Past the children in the bedrooms, right?
I carried her on my hands in the hallway, downstairs, into the garage.
Past the children in their bedrooms.
They were in the bedrooms, correct.
Down the stairs,
Yes,
into the kitchen,
yes,
into the mudroom,
yes,
into the garage.
yes.
And you put her in the Jeep.
I put her on the passenger seat of the Jeep.
And then you drove to the pond at 1 Francis Street.
Correct.
We have exhibit 133. You drove her there, right?
I don't think I drove with the Jeep exactly there. That's right on the water. There were bushes. You couldn't drive there.
There was too much brush, but that's the pond that you drove her to, right? In that photograph in 133?
I put her in the pond on 1 Francis Street, yes.
You had been there previously.
Excuse me?
You had been there previously.
I was there 2 years before, looking at the house because Katie asked me to, because she wanted to possibly buy another house.
It's Katie's fault that you know about the pond?
Excuse me?
It's Katie's house that you know about the pond? It's Katie's fault that you know about this pond?
Did Katie what?
It's Katie's fault that you know about this pond?
I didn't say that, no.
My question was that you had been to 1 Francis Street previously.
Correct.
And you knew that it was for sale. Could we have exhibit 309, please?
Yes.
So you knew it was unoccupied.
Yes.
Pulled all the way up.
Sorry?
You pulled all the way up next to the house.
I do not remember exactly how far I drove into that property. I don't know.
You told the police in the interview that you pulled all the way up, right?
I was struggling with memory when I gave that interview.
All right, should we get the transcript? All right, let's come back to that. Certainly you'd agree that you didn't want to be seen putting Katie's body into the pond, right?
That wasn't a concern of mine, I believe.
That wasn't a concern of yours?
I didn't think about all that, no.
You thought about where to put her, right?
I was thinking about not having her being found in the house by her children, yes.
And you decided that the pond was the place to put her.
It took me a while. I was in panic. I couldn't really remember much of anything that happened, and I tried to figure out, where to go.
All right, so if you look at page 75, that's where you're talking about the garage, right?
Yes.
Did you park up by the garage, or did you park down closer to the pond?
Here, I'm saying right there, and then that's the garage. I don't know what I mean with that,
Okay,
because I was confused.
you were confused. All right, but you were able to give accurate directions to the pond, to the police, right?
I had no recollection of the street names at that time, again, showing that I was confused. I just told them right, left, because I couldn't remember the street names.
But you knew the names of the street ordinarily?
I did, used to, but not at that time. I was completely out and confused.
You were completely confused when you were speaking to the police?
Well, there was a lot of confusion, a lot of shock, a lot of grief. I just went through a trauma myself. I mean, it was a very traumatic event. I just was in shock.
The event was traumatic to you.
Yeah, I didn't like to cause death of another human being. I spent all my life to save lives. So I was pretty much in shock myself of what happened, yes. I was extremely sorry and guilty and shameful about what happened, yes. I struggled with that throughout the whole interview. That's why you see all this, I don't know, I'm sorry, I don't know. I was struggling.
Let's go back to what happened on the, after you killed Katie, all right? You took her out of the car regardless of where you parked. And you traveled through all of the brush and the greenery around the pond, right?
I do not recall the botanical stuff, but I walked through brush to the pond, yes.
Well, you just said the marks on your hands were from the brush.
Yes, yes.
You're talking about this in 315, right?
No, there were also bushes a little higher. I remember that there was a lot of resistance as I walked through.
And certainly the police documented that in their pictures as well, right?
That's where my scratches likely came from, yes.
Okay. And you had boxer shorts on?
Yes, we had sex, and I put the boxer short on. Is all I had on at the time of the event, the tragic event, and later on, correct?
All right. And you're saying that you didn't take Katie's shirt off?
I do not recall, no, I didn't take it off. I don't even remember that it was off.
So I mean, showing you what's been marked as Exhibit 308. Is this her tank top?
I believe so.
Is this what she was wearing when you killed her?
I think so, yes.
And I understand that you weren't able to look at the picture in Exhibit 146, but you're aware that there's a picture of that shirt on a tree branch, right?
I was told that that was on a tree branch, yes.
Okay. And certainly you didn't want a shirt ballooning up and helping Katie float, right?
I had no intention to think any of that. I just wanted to put her away.
Well, you said yesterday that you were concerned about her floating, right?
No, I did not say that.
So you said yesterday that you put the rocks in her after you noticed that she was floating, right?
I put her in the water as far as I recall. Again, remember that I had a lot of intoxication and I was struggling with the whole situation, that I was extremely upset about myself. And as far as I remember, I put her in the water and I was kind of surprised she was floating.
Okay, so you were upset about yourself and you were intoxicated, I understand that. But when you put her in the water, did you push her out?
No, I was very careful with her. I just walked into the pond. I walked into the pond and put her gently down.
You walked into the pond and you put her gently down. And then did you turn around and walk back out to the shore?
No, I was looking and seeing she did not go underwater. As far as, again, I remember, and I was kind of, well, why isn't she going down?
All right, and you didn't want her to be discovered, right?
It wasn't really a concern of mine. I was going to kill myself.
But then why did it matter whether or not she wasn't going down?
Again, I was not really capable of rational thinking at that time. Sorry.
Well, if you didn't want someone floating, putting rocks in them would be a good idea. You'd agree with me about that, sir, right?
About rocks, I stumbled over them by accident looking for something to bear her down.
So you were looking for something to weigh them down, and you didn't put leaves in there, right?
Again, my rational thinking was massively impaired. I didn't think about any leaves or anything that you're suggesting. I just looked for something.
Well, I'm
that would bear her
suggesting
down.
it's rational. If you want to weigh something down, you use rocks. You agree with me about that?
Again, you are assuming that I was fully capable of cognitive behavior, which I was not.
I'm not making assumptions, sir. I'm asking you a question about whether or not it's rational if you want to weigh somebody down to use something heavy like 2 large rocks.
Again, I wouldn't call it, I would use the word rational. I wasn't rationally thinking because I was completely drunk. Just reacted. I reacted to what I saw,
There's not a question before you, sir.
so I just wanted to, sorry.
You got the rocks. Where was Katie when you got the rocks?
She was still in the pond.
Did you go get her and bring her back to the shore? Or did you bring the rocks to her and stick the rocks in her pants while she was in the water?
I believe I brought the rocks to her.
And then she went down a bit, right?
Correct.
So then you walked back to the Jeep
Yes.
and you drove back to 29 Valley Road.
No,
You didn't drive back to 29 Valley Road?
not at that time.
Where'd you go?
I tried to go, I drove to the hotel first, or on the way to the hotel.
You drove to the hotel all the way?
No,
Partway.
partway.
How far'd you get?
I have no recollection again. I was completely out.
All right, you've never said that before though, have you?
Believe I said that I was on my way to the hotel and I recognized that I didn't have my phone because I wanted to say goodbye to some friends.
Okay. So you realized that if you wanted to accomplish the task of saying goodbye, you would need to have your phone, right?
Again, you're subjecting, well, you're assuming I had a lot of rational thinking going on. That wasn't the case. I just saw I didn't have any communication device and I thought, let's go back and get my phone.
Because you understood that you could use the phone to communicate with people.
I'm not sure if I understood that, but I wanted to say goodbye and I didn't have any tool for it.
Okay. And you understood that your phone was at your house.
I assumed.
Okay? It seemed like a logical place to look.
That's correct.
And you changed into your jeans, right?
Well, I didn't change. I didn't have much clothes on except my boxers.
You put your jeans on.
Correct.
Because that made sense. When you were walking into the hotel, it would make sense to wear jeans.
I didn't think about that.
Okay. And you also picked up your wallet, right?
Was coincidentally that I walked by it and grabbed it as well, yes?
Okay. And you picked up a bottle of whiskey.
I don't recall that.
Well, when you were in the Jeep, you had a bottle of whiskey next to you, right?
I don't know how often I have to repeat that. I wasn't really thinking clear.
I'm asking whether or not you had a bottle of whiskey. I'm sorry my questions seem repetitive, but if you listen to the question, you'll understand that they're different questions. So was there a bottle of whiskey next to you in the Jeep?
I don't know.
Do you want to see a picture?
If you have one, please.
All right, Ms. Gelman, can we have 106, please? That's a bottle of whiskey in the Jeep, right?
That's what the picture shows, yes.
All right, was there always or routinely a bottle of whiskey in the Jeep?
No,
All right. And the knife that's there, you said that that was typically in the glove compartment?
Or let's say, there was typically a knife somewhere in the car, mostly in the box, in the glove box, correct?
Did you take the knife out of the glove box?
I don't think that I did, or I don't recollect or recall any of that.
All right. When you were driving, were you drinking from that bottle of whiskey?
I have no idea. I don't know.
All right. But you left it in the car. You didn't bring it into the hotel with you.
The picture shows it was in the car, so must have left it there.
All right. And you drove back to Dedham.
I drove to the hotel to take my own life.
On some windy roads, right, sir?
I do not recall what kind of roads I was driving. I don't remember.
You didn't crash, though, right?
That was a miracle, I think.
I'm sorry, I didn't hear that. Can you say it again?
That was a miracle, I think,
Okay,
that I
thank you.
didn't crash, given the fact that I was completely intoxicated
And suicidal, right?
and suicidal.
But you didn't crash into anything.
I don't think so.
Okay. You drove to the correct hotel,
Yes.
and you parked the Jeep in front of the hotel
I don't know where I parked it.
in a parking lot.
I do not know.
And it was between the lines, albeit close to the curb. Do we have Exhibit 118? That's the Jeep parked in front of the hotel, right?
It appears that way, yes.
When you say it appears that way, are you uncertain?
I don't see the hotel really. I see a couple windows and a wall. I don't know if that's the hotel.
Okay. And so let's have the video exhibit. Ms. Gilman, could we have the second video from the residence in, please? Exhibit 278. Pause it, please. That's you, right?
Yes.
You have something on your face?
I don't know.
Go back a little. You wearing a mask?
I have no recollection of that.
Were there rules that you had to wear a mask in the hotel during this time period?
In May 2020, I believe there was a rule.
And that's you coming in, right?
I don't, it looks that way that I walk in, yes.
You have your jeans on, your shirt, right?
Yep,
That's the jeans and the shirt that were introduced into evidence, right?
yes.
Your belt,
I don't see a belt.
press play. Were you able to see a belt in the video?
No,
Would it make sense you had a belt on?
probably.
Did it appear like your shirt was tucked in?
Yes,
You went through the front doors of the hotel, and you had to use your key card to get in?
I don't remember if that was necessary. I don't know.
And you went to the correct room, right?
I went to my room, yes.
Which was at the end of that long hallway?
I have no recollection where it exactly was.
All right. And you took a knife to one of your wrists?
Sorry?
You took a knife to one of your wrists?
That's what, again, I do not remember that act exactly, but I have a scar on my left wrist.
You have a scar?
I have a scar here on my left wrist, yes.
All right. And the hospital characterized those marks as superficial. You aware of that?
No,
You didn't have any stitches or anything, right?
I do not know.
Were there any marks on your wrists that you were trying to cover up?
No, I wanted to kill myself.
No marks from Katie on your wrist?
Katie had no skin cells under her nails, so no.
Katie had your DNA under her nails, right?
I lived with her for 4 days, 24/7. That's natural to have some DNA on your hand.
Sure, sure. But she did have your DNA under her nails.
I was all day with her, very much intimate. Yes,
All right. And certainly, Dr. Tuerk, you're aware that there are effective ways of slicing your wrists to initiate self-harm that results in death, right?
yes.
And you got back to the hotel, into your room, and you started drinking again, right?
I have no recollection of that. I do not remember how I got to the hotel or what I did in the hotel. I was drunk, really drunk,
And isn't it possible that you drank more in the hotel room?
certainly.
There was a bottle of whiskey also in the hotel room, right?
I drank basically all day, or not all day, but I started at 4 or 5 the night before and continued because I was really scared about what Katie was trying to do.
Well, you weren't scared when you first started drinking, right?
No,
That was just fun drinking.
sorry, what?
That was just fun drinking, right?
Yeah, she made martinis on the Cosmo, and we sat on the back deck and had a couple drinks, correct?
And then you weren't scared when you were drinking after you killed her, right?
I was in panic. I was definitely scared. My anxiety?
Katie.
No, but I was scared.
Okay. And you woke up in the hospital, right?
Yes.
They had pumped you full of IV fluids.
I don't know what they pumped into me.
All right. And you woke up in the early morning hours, right? On Saturday?
All I know is I woke up and I was in the ICU. I don't know what the time exactly or what day. I actually asked the gentleman what day it is.
But it wasn't until later in the day that you spoke with the police, right?
I think it was somewhere around 5.
So it was 30 hours after you had been taken to the hospital by the ambulance that you spoke with the police, right?
I do not know when I was taken to the hospital.
All right. Does it make sense to you that it was around 11 in the morning?
I really don't know. I think I was passed out.
All right, let's look at the medical records. May I approach? All right. May I approach?
Yes.
So, looking at your medical records, you agree that by noon, you're getting results from testing, right?
Results or
Texting?
orders?
What is it? Texting?
Results from testing
I'm sorry, thanks.
by noon.
Was on May 15, 2020 at 12 noon.
Okay.
Actually, it says 12. It doesn't say AM or PM.
Well, but usually hospitals take, document things in military time, right?
Well, they're doing tests 24/7. So it could be AM
It could be AM or it could be PM.
because there is no specification of afternoon or morning.
Do hospitals normally do test results in military time?
I don't think so.
You don't think so?
No.
Okay. Well, certainly you're aware that the police arrived at sometime after 10 in the morning. Are you aware of that?
I think it was the afternoon when they arrived.
You think it was the afternoon when they arrived?
I believe so.
Okay. Let's just do
Of-
one thing at a time. First of all, just so we're on the military time, you see this test indication on the 16th at 16:25?
Yes.
All right, so Norwood Hospital is using military time, right?
To that, yes.
Yeah, okay. May I approach?
You may.
I'm going to show you a Dedham Police report of Lieutenant Gonski. If you could just look and see if that refreshes your memory about what time the Dedham Police were called.
I don't know if that refreshing my memory is appropriate. I was unconscious. I was, I think, unresponsive, I was described. So that says here, what does it say here?
If it's not helpful, I'll take it back.
I don't know, what was the question?
If it's not helpful, I'll take it back. But you agree at least that you were speaking to the police after 5 o'clock
I think it was around 5 o'clock, yes.
on Saturday.
Excuse me, so the tragic events happened on the 15th, I believe. The next day, yeah, 16, Saturday.
You killed her in the early morning hours, right?
I didn't intend to cause that.
Then you went back to the hotel. You were transported to the hospital sometime late morning on that
I don't know.
Friday.
I don't know what time. Again, I wasn't conscious at that time.
You agree you were transported to the hospital on Friday. You're not challenging that, are you?
If you're asking me what I remember is that I woke up in the hospital, so I must have been transported to the hospital, yes.
On Friday.
Yes,
And then you're speaking to the police after 5 o'clock on Saturday.
that's what it appears to be. Again, I asked them even what day it was.
And certainly you felt better after you told the police what you'd done, right?
No,
You
I
didn't
felt-
feel better after you told the police
no.
what you'd done?
I feel today terrible. Never really changed. I'm so sorry about all that shit. Sorry. I'm not feeling better. I never felt better about what happened.
Didn't feel better to say where she was?
Now, you asked me if I felt better. I did not feel better. I feel guilty and ashamed from day one. And I wish I could make it all go away. I mean, in terms of having a return.
That would be better if you could bring her back to life,
I would love to bring her back.
but you can't.
Fortunately not.
And certainly you understood that one of the reasons that the police wanted to find her body was so that she could have a decent burial with her family, right?
Yes,
And you wanted to provide that as well, right?
yes.
And the police were right about that.
Well, I think I was right about that.
Oh, you were right. No further questions.
Just a few. Council was asking you about the circumstances of the blow to your head, the crashing glass on your skin, and then your reaction with your hand. You recall those questions?
Yes,
Question as to any statements or whether or not there's any conversations. Did she say anything to you at that point?
yes.
What did she say?
So get the fuck out of my house.
This is after the deed was signed, right?
Correct.
Did she say anything else about the car or the hotel?
Yes, she said a lot of things. She was yelling at me for
What did she
over
say
an
about
hour.
the car in the hotel?
About the car in the hotel. She said, get the fuck out of my house and you can walk to the hotel because the car is mine. The judge said so.
Now, I'm going to approach you with the phone dump that was performed of your phone and Ms. McLean's phone. Now, your phone, if I am correct, was 617-594-8962.
I have a hard time remembering after 5 years. I think it sounds right.
And you were obviously carrying the phone as Ingolf Tuerk, right?
Correct.
And Ms. McLean's phone was 339-222-9407, correct?
Correct.
And the two of you were texting back and forth, right?
Correct.
Now, have in mind the time frame council was going over would be, obviously, you met and the two of you lived together for 2 years, right?
Correct.
Then you got married for about 5 weeks, maybe 5.5 weeks, and then the divorce, right? Was implemented?
Yeah, I wanted the
Yes.
divorce because
Yes.
I wanted to move on.
Just answer my question.
Yes,
During the period of time you already detailed, and council asked about the trailers and all that, you stayed at a lot of places, right?
yes,
And you were concerned about the pandemic and dying bluntly.
I was scared to death, yes.
During the April month, is that when Kurt reached out to you, your friend Kurt reached out to you on a FaceTime and had you speak to Ms. McLean?
That is correct.
And was that the time that, tell us what was said at that point?
I do not recall the exact conversation. It was a pretty lengthy conversation, but the essence is, Harry, I still love you, come home. But there are conditions. You have to,
So you ultimately adhered to those conditions, correct?
I had to,
And you signed the deed,
I had to,
and you signed the post-nup,
I had to, yes.
and you heard the attorney and you saw the letters. You know the attorney, your own attorney, advised against this, correct?
Yes, he said that you shouldn't do that.
But you did it anyway.
I was so desperate for a safe place to be that I did it, yes.
Did you really think during this period of time, April into May, that the two of you were going to be reconciling? Did you feel that things were going to be good, you guys were going to love each other again?
I kind of was hoping for it because I didn't see much other choice than going back home. I didn't have a place to stay. I wanted to go back in my home.
Council had asked you about the sex and the frequency and things of that nature, correct?
Yes,
Would you agree with me, sir, that there were a number of text messages where she would text you?
Objection is to form.
Form, okay?
Just rephrase it, Mr. Reddington, please.
Sorry, Judge?
Just rephrase it.
Yes, thank you. I'm going to approach you with, this would be on May 5, 2020. This is a text from, let's abbreviate it, 9407 to Ingolf, Tuerk, 8962. So that would be,
Can I just have a minute, please?
Yes.
that would be on page 1501. So I'm approaching you, sir, and handing you what appears to be a list of text messages from a Celebrate phone dump. Does that appear to be text between you and Ms. McLean?
yes.
All right, and what's the date of the text messages? Representative, just read that.
Here on this page, May 5,
So this is May 5.
correct.
Now, on May 5, had you actually started living back with her again? Are you still in the hotel, but you were
And May 5, I was in Florida still.
still in Florida?
Yes, sir.
Okay. At that point, you're telling the jury that she had indicated that she wanted you home, right?
Correct.
You guys are going to love each other again, right? Yes?
We tried.
Look on that text and see.
This one here?
There's an indication. May 5, 2020. You're on with the foundation of text from Vernon Inn. Can that be brought up on the screen?
Could we approach?
Yes.
Recall your testimony, sir, indicating that there were, on a number of occasions, that sex was a very important aspect of this relationship, correct?
Correct.
And in reference to text messages between yourself and Ms. McLean. I'm going to
Sorry.
ask that you on May 5, 2020, there was a discussion between you and Ms. McLean telling you to come home, and then the next box says, and come home and have sex with your wife. Is that indicative of the type of text that you received from her?
Yes.
Now, in reference to counsel's questioning about the menstrual period and the blood that was on the bed, you heard the testimony from the DNA person and the crime guy talking about there was a round spot of blood on the bed, right?
Yes.
You were asked questions on cross-examination from the district attorney as it relates to the nature. No, didn't anybody wash the bedclothes and things of that nature, and showed you photographs of your washer and dryer, right?
Right.
On May 6th of 2020, page 1526, it would be text number 4074 through 4077, please. Do you recall receiving, let's write that, do you recall sending her texts referring to you to her? I will like you for the rest of my life. And the two of you are making arrangements for you to go over there and meet up with her on May 6th. Do you recall those texts?
Meeting up with her?
Yeah, over at the house, yep.
May 6th, I was still in Florida.
Okay. Do you recall her telling you to come home? When did you come home?
I drove back from Florida to
When? What was the date?
7, and then 8 I arrived in Massachusetts, and we went to the hotel and had sex.
Okay.
First thing, twice. She wanted that. And
Do you
then I went
recall?
home on May 10th, sorry.
May 10th, that's the answer. Do you recall on May 7th, that would be page 1529, and she sent you a text, "Good morning, I am excited to have you come home safe." Do you recall that text?
Yes,
On May 6th, do you recall discussing between the two of you, your coming home and being with her?
yes,
You recall on May 6th would be 1526, discussing coming back together. You asked, what if you don't like me anymore? Strike that, I apologize. That was a text from Katie to you. What if you don't like me anymore? Your response, I love you, Katie, you are my wife. I will like you for the rest of my life. And then she responded, okay, well, I have my period now, and most likely will still Friday, so not sure about sex. That was on May 6th in the afternoon.
I recall that.
And one of the addressing May 9th, should be right after the 6th. Do you recall her sending you texts, page 1541, where she texted you, I love you, Harry Tuerk. Last night was the very best lovemaking I ever felt. I felt so safe and connected to you, with you, thank you. I love you, etc. You blew me away, Harry, both times, but that second time you were all there, all in.
I recall that text messages, yes.
And in between the text messages and your feelings, state of mind that the two of you were going to be husband and wife, get back together again, did you have any knowledge whatsoever that Kurt, your friend, was having practically daily conversations with her, including asking to show him her boobs?
Objection beyond the scope.
Okay, overall, just a yes or a no.
I did not know.
But nevertheless, one of the issues that was of import was the signing of the deed, correct?
That was very important to her.
You recall that she berated you about the fact that you sent the deed to your lawyer instead of sending it directly to David.
Objection.
No, overruled.
Yes, she was angry with me that I delayed the arrival of the deed.
And ultimately, it was recorded, correct?
It was recorded actually on the day when the tragic events happened. It was one of her things. She yelled at me.
That's all I have, Ron, thank you.
Nothing further.
Okay, you may step down.
All right, so jurors, we're going to go into closing arguments. I would ask that you put the instructions that I gave you, just put it under your seat and put your notebooks under your seat. Closing arguments are not evidence. And then when I resume the instructions, obviously, you can take the instructions back out. Ms. Reddington?
Thank you. Members of the jury, thank you again for your attention. The time you took away from your family, your work, to sit here in a courtroom for a long time and listen to evidence. And when you think about the beauty of the jury system, is that a citizen, when they're charged with a crime, has the right to have a jury of their peers sit in judgment on the case. And you're all, people come from all walks of life, different jobs, different backgrounds, upbringings, and you have your common sense, you have your life experience that you bring to that jury room when you sit down and you deliberate the case, and you determine whether or not, consistent with your oath as jurors, that the government has proven the charge beyond a reasonable doubt. And you heard His Honor explain to you what beyond a reasonable doubt is. Often used, hard to explain. He did a pretty good job on it as far as explaining to you that close is not enough. More probable than not is not enough. They have to have proof beyond a reasonable doubt to the highest degree of certainty in lives of human beings. You heard His Honor indicate that the government, anytime the government charges somebody with a crime, the government has the burden to prove that person's guilt beyond a reasonable doubt, and that is up to the government. They determine what charges are going to be leveled against someone. They determine what the person is going to be charged with, and then you have, the judge will give the jury the elements, the building blocks of the case, what the jury considers as far as whether or not they've proven a particular charge beyond a reasonable doubt. And the burden of proof in this case lies squarely on the government, on the Norfolk County District Attorney's Office to prove to you beyond a reasonable doubt the allegations. Murder in the first degree, premeditated malice aforethought, cruelty and atrocity, the worst thing we ever reserve on cases. First degree murder, second degree murder, murder, the intentional killing, taking of a life, knowing what someone is doing, having the ability to think, deliberate, plan. Whether or not they react, the government has to prove that this killing was not as a result of self-defense. They have to prove that it was not as a flow from a reaction to an assault that is the culmination of the plan. There's a plan here for sure. And the plan was on the part of Miss McLean to get that house, to get his money, and get him out. You can see a lot of these issues, you can see by evidence, not what someone says to you here in the courtroom, but what was in existence at the time. Text messages speak volumes because they show what's in someone's mind at the time that they send the text message. Photographs showing the scene is important because they show, for example, the shattered glass all over the bedroom floor in the front of the bed by the end board. The glass that's broken, that's up on the piece of furniture. The other glass that's broken, that's underneath the other piece of furniture. All of those items speak volumes as to what happened that night. That night, which was the culmination of the McLean plan, and again, you look to the texts and the evidence that was in existence. If he dies, do I get the house? If he dies, do I get the house? You saw that from the text twice that she sent to Mr. Keighton about the deed, the deed, the deed. Get on the house, get on the property, get on the property, you own it. If he dies, you get it. Height of the pandemic, get out. You heard, get out. Get out, go walk to your hotel. Leave the car's mine. No, it's not. Well, the judge says it is, as is the house. This is all about money, all about money. And she played him pretty darn good. Smart guy, obviously, in an operating room. Not a smart guy when it comes to real life. You heard the background, you heard his life story, you heard he learned English, taught himself English, rose to the pinnacle of his profession, specialized for a while dealing with pediatric oncology surgery, robotic surgery, all of that, wonderful. Doesn't mean anything, it's ashes blown in the wind. Because he had the pleasure of meeting Kate McLean on Bumble. And they went out on a date. A lot of people do. Many people get together as a result of that. God bless them, that's awesome. If they have a good relationship, wonderful. You think about it. He's living life large. He's got his Harley Davidsons. He's got his house. He's got his job. He's got his money. He can go out on dates. He can stay at home. He can go do whatever he wants to do. 2 years. 2 years they lived together. She comes in with her 3 children after a number of weeks, brings the 3 children into his house, welcomes them in. They lived together for 2 apparently uneventful years. He's paying the bills, taking care of the house. She's got the 3 kids there. You heard evidence that during that period of time, Mr. Rocca, saw the man with the beard, his father, he's trying to visit with his kids. Couldn't visit with his kids. Had to park his car out in the street. You heard all that. This is Katie McLean. Katie McLean's life. Then, all of a sudden, she applies for a wedding license or whatever, marriage license. Applies for the marriage license. Gets the marriage license. He's going out to Las Vegas to do a thing. We're talking about elderly medicine at the Bellagio. And he takes her along. Next thing you know, they're going through, and again, I don't have to hold up pictures and I don't have to have visual aids. You're intelligent people, you sat here through this trial, you know what the photographs show, you know what evidence has been presented to you, you know that they went through the Elvis drive-through, who does Elvis drive-through wedding? Well, hallelujah, we're married now. 5 weeks. 5 weeks. And then he reaches out to an attorney and says to the attorney, look, I want a divorce or an annulment. One or the other, I don't care. I want out of this. 5 weeks. She goes on his phone, you get evidence, she goes on his phone, she checks his phone, she's looking for girlfriends, texting, what are you doing? Who are you doing it with? Let me see it, give it to me. And she sees that deadly email from the attorney, Mary LaCivita. And do the math. It's a day or so later that she gets her bogus restraining order. Throws him out of his own house. He's now out. You heard the officer testify. He was a gentleman. He wasn't some crazy ranting person, angry, upset. Had his hands on his knees. He's like hyperventilating. Please, do we have to do this? What do you mean? I'm out of my... You gotta go. Okay, Katie McLean says, you gotta go, you gotta go. Now, she stays in that house. She has a place in Belmont, her mother's condo in Belmont. She could have gone there. No, she likes Dover. She loved Dover. The kids loved Dover. Because Harry went because they wanted. They have entertainment. Harry builds the theater. He builds the swimming pool. You heard about the waterfalls and the TVs and the entertainment thing because she liked to entertain. He didn't say that like, oh, she liked to entertain. He said just like, Katie loved to entertain. He had an affinity, he had a respect for her, he had a love for her. He wanted her to be happy. He built all these things in the house to make everybody happy. Support everybody, no problem, take care of everybody, not a problem. Well, once the passage of time goes by, into, what is it, February of 20, he's with Charlie Lax. Friend who allowed him to come in, no problem. After that, he ends up for a period of time with Richie Kovitz. You saw Richie Kovitz, nice guy, testified, had to go to Florida, he lives in Florida. He let Harry come in to his condo with his girlfriend, fiance, Carla, for months. Harry stayed there for months. Pandemic hit. We all know that. We all lived it. We all know how horrible. Many times people were drinking wine at 11 o'clock in the morning. You don't know if you're going to die the next day. You don't know. Go into supermarkets, you get arrows telling you, go this way, go that way. Wear masks, can't eat, can't go to a restaurant. He, meanwhile, doesn't have what did the police officers say? Shelter in place. He doesn't have a shelter in place. Because now, after he went to Germany, again, he has his life back on track. He's got a job in Germany with robotic surgery. Katie McLean and her 3 kids are in the rear view mirror. He's moving on. He's getting a divorce. He's moving to Germany. And he's going to have a darn good job working at that hospital. Not to happen. Because at the height of the pandemic, he has to come back. He's back because of the presidential decree. Comes back to Massachusetts. What's he going to do? Goes to a hotel. Okay, fairly expensive. If you recall, maybe you have life experience during that period. You can't do anything in a hotel. You can't eat. You can't go to a restaurant. You can't do anything. So he's living in a hotel. He's communicating as time goes by with friends or family, and during that period of time, he ends up with Kurt Pfannenstiel. Good old Kurt. His best friend. Kurt backed up on that like a poodle on a linoleum floor when I asked him, you're his best friend? Well, no, I'm not his best friend. I mean, yeah, I know the guy. I was friendly with Katie. I guess you were. Do you really think that Kate McLean had the intent to take this guy back into her life? Do you really think that Kate McLean wanted to have this old man back in her life and she loved him? She has her goals. She reaches out to him. You heard the governor jump up and down and ask him, well, you're the one that wanted to reconcile. Katie McLean has just had many friends. Wonderful, wonderful woman. You wanted to reconcile with her. And I suggest to you that his testimony was consistent because it's the truth. And he testified and told you under oath that it was Kurt Pfannenstiel that reached out to him initially on a FaceTime call with Katie McLean. Come back. Now, meanwhile, he's in Florida, right? He's living in a trailer in Florida. How the mighty tumble. He's living in a trailer. Got to get out of the trailer. You can't fall much lower than that when you got to get out of the trailer. So he's got to leave the trailer, and now he's got his problem with his head and his back, and he's got to come back up to Massachusetts. Well, Kurt comes to the rescue with that call. I love you. I want you back. He now sees a light at the end of the dismal tunnel. And during that period of time, he is able to make arrangements to meet Ms. McLean in New York, drive back. She's got Mr. Roca with her. He told you he was shocked, surprised, because that was the last guy in the world that he expected to see her with. You heard evidence that during this period of time that she had people in the house, and she's certainly not entertaining her friends. During this period of time, he's thinking that they're going to reconcile, but right up to the very end of that period of time, she's not in a mindset that she wants to reconcile. She's more interested in talking to guys and doing whatever she's doing with Kurt, and you heard the evidence. What do you think was in her mind? You think she really wanted to reconcile? No, she wanted the deed. She wanted the house. She wanted the security. We can say security. She wanted the security. This fool signs a deed against his lawyer's advice. He says to him, don't sign the deed. Don't sign the post-nup. What are you, nuts? There is no basis for alimony of a 5-week marriage. You've been played. But he signs the deed. He signs the post-nup. Makes arrangements to meet with her. Now, he then is living in that hotel that we saw, that little room. There's a restraining order. She drops a restraining order. Of course, it's part of the plan. Drop the restraining order. She didn't care if he was in the house. Come on, come in the house. Let's go, in the house. You're able to go in the house. He brings his little ditty bag, goes in the bedroom. Beautiful, everything's great. We're going to live together. Things are going to be great. We're going to reconcile. Didn't know about Kurt. Didn't know about the text. Didn't know about that state of mind. During that period of time, they end up, and it's not easy to talk about people. I mean, the woman is dead. As an attorney, I'm not stupid. I know you don't, as we say, trash the victim. I know that. But it's the facts of the case. And if I was arrogant or obnoxious, or I was hard on a witness, don't hold it against him, because that was my cross-examination. But in my opinion, I did what I believed that had to be done to show you what the truth is and was at that time. So he's now in the house with her. He said that it was sex, sex, sex. Said that at his age, it was a little overbearing, but nevertheless rose, so to speak, to the occasion. During that period of time, I had texts that showed it's 11:45. Let's fuck. Come home. And whatever she said, with your wife. Do this with your wife. And interestingly enough, the round spot of blood on the bed that is hers, yes. You have a text where she indicated on May 6th that in fact she's telling him I'm on my period, so you can't have sex. We're talking a week later. They had sex. You heard the DNA the person talk? Yeah, that was her DNA. And 3 other contributors. My God, 3 other contributors. YSTR profile, male profile, in that spot, in his bed, in his bedroom. In any event, they have sex. He told you that night they had sex. You heard the DNA woman say, yes, if a guy is married to a woman or a guy and a girlfriend or whatever, and they're intimate with each other, yeah, of course there's going to be DNA in their hands or in their fingernails. This is not blood. This is not skin cells. It's touch or handler DNA from touching someone, rubbing someone's back, clawing someone's grab, grabbing their butt, grabbing their junk, grabbing whatever you grab, however you grab it, you're going to get DNA on your husband or wife's hands. But they run with that. That and the blood spot on the bed. Oh, you saw and heard. There's not one whit of evidence that she had a bruise about her face, her head at all. No evidence whatsoever of any bruising in the area of her face and head. Of course, we have the government's pathologist who testified, and it's your memory, not mine. Very nice woman. Testified as best she could. She's probably overworked. She had a lot of files, a lot of cases. And I suggest to you that she couldn't remember basic things from that autopsy. That's fine. She says, oh, there's subdural hematoma in the back of the head and the side of the head. Initially, is there any bruising? No. And then it was, well, subdural hematoma. Yeah, that could be bruising. Yeah, okay. Well, you heard Dr. LaPosada indicate that that is from the person being for a period of significant time prone over the water. And when we talk about the water, that is what is called post-homicide conduct. What's at play with a jury is what was in the person's mind at the time of the killing, not what occurs afterwards. Granted, you heard him testify. He's not proud of that fact. He lives with it. But it has nothing to do with what was his state of mind at the time she smashed the glass, which you believe obviously happened, off of his head. You saw the photographs. You saw it's almost an inch above the hairline of the cut. He indicates that he is holding his hand and reacts with one hand. You heard Dr. Lapisade's testimony. There is no bruising about the head or the face. There's no bruising anywhere, actually, other than the neck. Bilateral, not circumferential, not grabbing with two hands. Dr. Lapisade clearly and unequivocally states bilateral grab from a very, very powerful man with huge hands, okay? Bilateral grab. Reacting. Both of them drunk. She dies. He knows. Is that premeditated? Is that cruelty and atrocity? A matter of seconds, Dr. Lapisade stated. Seconds. I suggest to you that he reacted. He was drunk. He reacted to the assault. He defended himself. He did not use excessive force. He reacted to stop the assault. Any one of you or anybody is entitled to defend themselves. And the beauty of the law is that the government has to prove beyond a reasonable doubt that he did not act in self-defense. They have to prove. How can anyone say he did not act in self-defense? That's a not guilty. He acted in self-defense. The circumstances attending that set of events that occurred, the government has to prove to you beyond a reasonable doubt he did not act in self-defense. The government suggests that, oh, this is first-degree murder. Second-degree murder, when you look at the facts of the case, consistent with the instructions his Honor gave you, is this a killing that occurred in hot blood, heat of passion, on sudden, adequate provocation? Isn't that all over the place? They have a burden to prove to you beyond a reasonable doubt that he did not act on reasonable provocation, did not act in a heat of passion, did not act because of the emotion of the assault, did not have the ability to form intent at the time. There's no intent to kill. There's an intent for self-preservation. You heard Dr. Zeisel talk about fight or flight. You heard Dr. Zeisel talk as a psychologist about pretty fairly standard psychological principles that all of us have. That little hypothalamus or whatever it is, that thing in your brain, tunnel vision, you do stupid things afterwards, you try, it's because you're nervous. It's the overwhelming fear, the overwhelming fright that eclipses your ability to think straight. That's what the pond is about. The pond has nothing to do with the circumstances of the killing. The killing occurred, she smashed the glass, after she told him to get the F out, get out of my house, and the deed was recorded that day. And he moved in that night, that day. One night. The evidence shows shattered glass. Do we have it? No. Where is it? Who knows? Maybe a dump somewhere. Is that important to have a full fair investigation? You heard, and you know, the cops, you can wind them up and they'll walk up to the witness stand and you can press the button and they'll testify and they'll give the right answers. But Does anyone really think Kwiatkowski knew what the hell he was doing? Here, testifying? He didn't even know where the argument took place. He stood up there and told you, I don't know. It's possible. It's possible it took place in the bedroom. Come on. Was there glass on the floor? I think I recall. What do you mean you think you recall? You're a chief homicide investigator on a murder case. Man's life is at stake and you think you recall because you get your check on a Friday? That is a lousy police investigation. And you know what? You know what? The other young man that came in and said, well, if it had red marks on it, I would have examined it. And I said to him, you have to know it's there before you can examine it, right? He didn't even know that there was a second glass. When the police investigate, as citizens, we expect they're going to have an open mind, they're going to do a good job, they're going to seize evidence, they're going to secure things, and they're going to do the best they can to be able to prove a case to a jury beyond a reasonable doubt. Didn't happen in this case. It was a foregone conclusion, but they knew nothing about text messages, did they? They knew nothing about the goings-on between the two of them. They knew nothing about the deed. They knew nothing about the post-nuptial agreement and the money that's paid. They knew nothing about the destruction that she rained down on this man's life. This is not a murder. You bring your common sense, you bring your life experience to that jury room, you look at all this evidence, you look at the time frames, you look at the deed, you look at the photographs, you look at the medical records. The medical records have the guy at the 226 blood alcohol 19. You see the comment in there, suicide by alcohol. And you can make fun of the fact, oh, well, you know, it's superficial scratch. Anytime there's marks and cuts on somebody trying to kill themselves by not going sideways, linear lines, they're superficial. Post-convict, you can say that's superficial. He wanted to kill himself. He wanted to say goodbye to his friends. He wanted to say, I love you to some people. He did that with Kurt and some of the other people that he sent messages to. She played us. She was the devil. I love you, Harry. This is the end of a tragic human story. But I suggest to you, members of the jury, that when you consider Judge Hallel's instructions, ever mindful of the burden of proof, this man is not guilty of murder. Thank you.
Thank you, Mr. Reddington. Ms. McLaughlin?
On May 15th, 2020, Katie McLean took her last breath with the defendant's hands wrapped around her neck, squeezing the life out of her. He took her lifeless body past her children's bedrooms, down the stairs, placed her into the car, and drove her to a home that she and the defendant had once looked at to buy for their family. He took her body through a dark wooded area with thick brush and trees and placed 2 large rocks in her leggings, and then he discarded her in that pond like a piece of trash. During the course of this trial, you have heard that Katie was married to Stephen Rocca and had 3 children with him. After that marriage ended, she was briefly married to a man named Chris Foley, and then in November 2017, she and the defendant met online and began their relationship. You heard that sometime in 2018, Katie and her 3 children moved into 29 Valley Road with the defendant, and her children began attending school in Dover. In December of 2019, Katie and the defendant were married in Las Vegas, but the relationship deteriorated, and by early February 2020, Katie had obtained a restraining order against the defendant, who was no longer living at 29 Valley Road. The pandemic hit about a month and a half later, and the world shut down. The defendant made his way to Florida and planned to sell the house at 29 Valley Road. Both he and Katie were moving forward with the divorce. However, on April 17th of 2020, that all changed when the defendant reached out through his lawyer, John Hoffman, and requested Katie consider a reconciliation. You heard testimony from Vanessa Pettigrew and Stephen Rocca that show Katie wasn't sure about the reconciliation, but she wanted to try to make her marriage work because she loved the defendant and she wanted stability for her children. So Katie and the defendant worked out an agreement to try to help Katie feel secure in the relationship, which included signing the deed on April 29th of 2020. To give Katie half ownership in the house, and the two also established a post-nut agreement. You heard on May 8th of 2020, Stephen Rocca drove Katie to New York to meet the defendant, and she and the defendant drove back to Massachusetts together. You saw surveillance video and the reservation receipt from the Marriott showing the defendant check in on May 8th with the intention of staying at the hotel until May 17th. But on May 15th, 2020, that hope of reconciliation came to an end when the defendant killed Katie in their bedroom at 29 Valley Road. And for that, the defendant is charged with first-degree murder. The defense suggests that the defendant killed Katie in the heat of passion or in self-defense. He was under extreme stress from the pandemic, had just placed her name on the deed of the house, and snapped that night when she threatened to make him leave again. He also suggests that because Katie had texted with friends about her relationship with her husband, and because she wanted stability for her children, that she just wanted his house and his money, and never really wanted to reconcile. And that, coupled with the fear of being kicked out of his own home during the pandemic, is what led him to snap. Ladies and gentlemen, I suggest that is not heat of passion. It is not self-defense. It is motive to kill. And the defendant's text to Kurt Vandensteel after the murder is further evidence that the defendant did not snap and kill Katie and then instantly regret it like he wants you to believe. That text shows his constant and enduring belief that Katie was a vindictive devil, and it shows his motive to kill her, to get rid of her so that he would not have to go through another divorce and he would not lose his house again. I want to remind you about the defendant's statement on May 16th of 2020. It was 1 hour and 20 minutes into that interview when the police first suggested that Katie had hit the defendant. Sergeant Kakowski continues to suggest that Katie hit the defendant with something. He tells the defendant about the broken glass in the bedroom and points out the small abrasion on the defendant's head. It is not until then that the defendant adopts Sergeant Kakowski's statement that Katie had hit him. I would suggest to you that the defendant adopted this theory to minimize his culpability as he was confessing to killing Katie. A killing that was driven by greed. As we heard numerous times throughout this trial, it was his house and it was his money, and he was not going to give those things up. In those moments, the defendant was not overcome with emotion or fear or panic. He was angry. And he wanted to make sure that Katie was not going to get his house. And the only way that would happen now that the deed was signed was if she was dead. And so he killed her. I would suggest to you that all of the evidence you have seen and heard throughout this trial shows that the defendant not only had the motive and intent to kill Katie, but he also had the opportunity when he got himself back into that house. I would point you to the evidence in the bedroom, the shattered glass all over the floor, Katie's blood on that bed in 2 different spots. The photographs of the scrape on the defendant's head, coupled with his medical records that documented it simply as an abrasion. the lack of red-brown stains on any piece of glass that was photographed in that bedroom, and the small cuts on the defendant's hands by his thumb and index fingers, with the evidence of the defendant's DNA under Katie's fingernails. This evidence is not consistent with a single blow from a glass and a quick grab to the neck that caused death. I would suggest to you what this evidence is consistent with is a violent struggle. A violent struggle as Katie fought for her life in that bedroom. And the extensive injuries to Katie's head and neck described by Dr. Matthews are just further evidence of that violent struggle for Katie's life that occurred inside that bedroom on May 15th. Now I want to talk to you about what some of the defense witnesses said. Think about Attorney Hoffman's testimony and the series of emails sent by the defendant on April 10th, on April 13th, and April 15th. He was still committed to that divorce, and he wanted back in that house. And he wanted Katie and her 3 children to move to Belmont. And then 2 days later, he suddenly had a change of heart and wanted to reconcile. He wanted to make Katie and the kids feel secure. So he put her name on the deed, which meant that she was entitled to half the house if they were to get divorced. But also remember that becoming tenants in common on a deed means if one of them dies, the other one gets the house. Dr. Laposadas testified that Katie's death was a result of a one-handed application of force. I would ask that you remember this is a doctor who has not examined a body in over 20 years. Her demeanor appeared aggressive and argumentative as she was testifying. And I would suggest, as a paid defense expert, she had an agenda. And she wouldn't even answer the simplest question on cross-examination without pushing that agenda. Dr. Laposada also made sure to emphasize all the things that she did do as she considered the cause of death and the circumstances surrounding Katie's death. But there are 2 things that she did not do. She did not examine Katie's body, and she did not listen to the defendant's statement to police from May 16th of 2020. The statements in which he said, "I choked her. I grabbed her around the neck, and she was fighting, and I continued, and then she passed out." The defense suggests that this was an impulsive, knee-jerk reaction. Dr. Zeisel testified that people in highly dangerous situations can have a fight or flight response and can act without thinking. He gave examples of hurricanes, mass shootings, and being attacked. But he also agreed in those situations, you do not lose your free will, and you do not lose the ability to make a choice. The defendant, who I suggest appeared methodical and detail-oriented, testified that he was down on his knees, begging Katie to stop as she was yelling at him and then hit him with a glass. He testified that he snapped and blacked out. But he did remember that he grabbed her by one hand on the neck. He described her flailing, and then they both fell to the ground, and he told you that when he came out of his blacked out state, he saw she was non-responsive. So he put her on the bed and started CPR. But it didn't work. I would remind you that in his original statement to the police on May 16th, 2020, he did not tell them he was on his knees. He did not tell them that he only grabbed her with one hand, and he did not tell them that he tried to perform CPR. In his testimony yesterday, he also told you that he panicked and wanted to move Katie's body so that her children would not find her. I would suggest that the defendant took the methodical and detail-oriented steps to dispose of Katie's body in an effort to save himself, not her children. At times during this trial, the defense has also tried to disparage, embarrass, and blame Katie. But I would suggest that is not what this case is about. And it was meant to distract you from the focus of this trial, which is the death of Katie McLean. Earlier, Judge Halal instructed you on the elements that the Commonwealth must prove beyond a reasonable doubt in order for you to find the defendant guilty of first-degree murder. He explained that there are two different theories by which the Commonwealth can prove first-degree murder. The first is deliberate premeditation, and the second is extreme atrocity and cruelty. I submit to you that the Commonwealth has proven both theories beyond a reasonable doubt. When considering the first theory, deliberate premeditation, the first element under this theory, it's not contested. The defendant admitted in his interview that he killed Katie McLean by strangling her. He told you in this courtroom that he killed Katie. And Dr. Matthews, the medical examiner, testified that Katie's cause of death was strangulation. The second element is that the defendant intended to kill Katie. The defense suggests that the defendant did not form the necessary intent to kill Katie, and they point to his intoxication and also argue that he killed her in the heat of passion or in self-defense. When thinking about this, I want you to think about the defendant's own words in his interview to the police. You always have a choice. And I would suggest to you that the defendant made a choice in the early morning hours of May 15th to kill Katie. Think about his other statements during that interview. She was fighting and I continued. Then she passed out. He had a choice to stop as she was fighting, and he did not. In those moments, he made the choice to keep going and to kill Katie. And I suggest to you that is intent. Attorney Reddington suggests that the defendant was intoxicated and snapped and could not control his conduct. When considering whether the defendant's drinking that night played a role in his behavior, think about the meticulous steps that he took after she was dead. He carried Katie's body down the long staircase at 29 Valley Road. He placed her into her vehicle and drove her to a pond that he had been to before. He walked in the dark through thick brush and trees, causing the scratches and abrasions to his head, to his legs, and his arms. Then he placed 2 large rocks in her pants to weigh her down, to hold her body down. Then he started driving to Dedham, but realized that he had forgotten his phone, so he went back to the house. He got his wallet, he got his phone, he changed his clothes, he locked the bedroom door. He drove those windy, dark, country roads from Dover to Dedham, without crashing, without getting pulled over, and then he parked within his parking spot. He put on his mask. He removed his wallet from his pants. He swiped his card around 5:30 a.m. to enter that building. He walked past the reservation desk, through the lobby, and up to his second-floor room. Not stumbling, not falling down, not incapacitated. I would suggest he is quite the opposite. He is cool, he is calm, and he is collected. His clothes and his hair are neat and orderly. And again, look at that coherent text he sent to Kurt about his hatred for Katie. This text does not show panic. It does not show remorse. It shows motive, and it shows intent. I would suggest to you that the defendant's behavior directly after the crime does not indicate that he was in a fit of rage or so intoxicated at the time he killed Katie. I would suggest to you it's the behavior of someone who is in complete control of himself. He is aware of his actions and the potential consequences, and he took well thought out, methodical steps to dispose of her body and cover his tracks. Also remember the defendant was alone in that hotel room for 5 hours with a large bottle of alcohol that was half empty when the police entered at 10:50 a.m. During that time when he was alone in the room, He had time to think, he had time to reflect, and he had time to plan. Likewise, the defense wants you to believe that the defendant wants you to believe that he was either intoxicated at the time of his interview or was feeling the effects of his prior intoxication. He wants you to believe he was confused, he had memory lapses, and he didn't understand what he was saying because of his blood alcohol level when he was admitted to the hospital. I would ask that you use your common sense and your life experience when evaluating these statements. The Dedham police arrived at the hotel around 10:50 a.m. on May 15th and found the defendant, who was immediately transported to the hospital. His lab results from noon on May 15th show his blood alcohol level to be elevated. But remember, the interview with the police did not begin until 5:19 p.m. on May 16th, almost 30 hours later. Remember the testimony of Ailish Wilkie, who told you it was her job to protect the defendant, and she would not have let him talk to the police if he was unable to or if he was unwilling to. Think about the defendant's behavior in that interview, how clear his voice was while even wearing a mask, how he was able to spell everyone's last name correctly without being asked. Think about the testimony of Detective Gonski and Sergeant Kakowski that the defendant walked in and out of that room unassisted. He sat up in a chair throughout the entire interview, and he was calm and coherent throughout that entire interview. All of these details, coupled with the police being calm and patient and allowing the defendant the time he needed, point to the defendant's statement being knowing, voluntary, and intelligent. The third element, whether the defendant decided to kill Katie after a period of reflection, Judge Halal instructed you that that period of reflection can be just a few seconds or minutes. I would suggest to you that the defendant's words to the police on May 16th, that Katie fought and he continued, paired with the small cuts around his thumb and his index finger and his DNA found under Katie's fingernails, indicate she was fighting him. And I would suggest it shows that he knew exactly what he was doing when he continued to strangle her as she was fighting for her life. The defendant's own words indicate he had time to reflect about his actions and those consequences. She was fighting and he kept going until she was dead. Also think about the fact that the defendant is a renowned surgeon. We heard a lot about that through this trial. He is trained to react under pressure. He has training on the human anatomy. But, as he said in his original statement to the police, he admitted he did not try to resuscitate Katie, and he did not call 911. Instead, he removed her body from the house. He weighed her down with 2 large rocks, and he sunk her body in a murky pond. Ladies and gentlemen, I would submit to you that all of that is deliberate premeditation. The second theory of first-degree murder that you must consider is extreme atrocity and cruelty. As with deliberate premeditation, we know the defendant killed Katie. And when considering the second element, his intent, again, remember the defendant has substantial medical training as a doctor. I would suggest that any reasonable person would know that cutting off someone's air or blood supply could result in death. The defendant, with his significant medical training, would have known that wrapping his hands around Katie's neck and continuing to squeeze as she was fighting him would reasonably cause her death. And during his testimony, he acknowledged that. The third element, that the killing was done with extreme atrocity and cruelty. When thinking about this element, I want you to remember the defendant's statements during his interview, as well as Dr. Matthews' testimony. I would suggest that the defendant continued to strangle Katie while she was fighting shows his indifference to her suffering. Think about the testimony of Dr. Matthews and the extensive injuries that she detailed, the petechia in Katie's eyes, the external injuries to her neck, the internal injuries to her head and her neck, and her broken hyoid bone. Remember where Dr. Matthews said the hyoid bone was, placed within the neck muscles, and the fact that Katie's hyoid bone was fractured. And the hemorrhages in her neck were 4 layers deep. Dr. Matthews agreed that it would take significant force for those injuries to occur, and that all of Katie's injuries occurred before her death. That, coupled with the injuries to the defendant's hands and his DNA underneath her fingernails, shows that she was conscious and suffering as the defendant was squeezing the life out of her. I would suggest to you that all of this evidence shows beyond a reasonable doubt that Katie's death was completed with extreme atrocity and cruelty. Ladies and gentlemen, you were instructed at the beginning of this trial and again at the end of this trial on the meaning of reasonable doubt. You have heard that the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment. As you consider how the Commonwealth has convinced you of the defendant's guilt as to first-degree murder to a reasonable and moral certainty, I'd ask that you remember the layers of injuries to Katie's neck, her broken hyoid bone, the fact that the defendant was a doctor with extensive medical experience, and he knew that strangling Katie would reasonably result in her death. The statements to law enforcement that he made, you always have a choice. The 2 large rocks that he placed within her pants before dumping her half-naked body in that pond. The text he sent to Kurt after he had killed her and disposed of her body. That, members of the jury, is proof beyond a reasonable doubt. I'd ask that you consider all of the evidence and return with a verdict finding the defendant guilty of first-degree murder. Thank you.